glad Sean was able to show you photographs, because the one thing I'm not is a photographer. So mine will just be words. And I'm usually doing a lot of copyright education and talking about releases and what copyright is, but I'm going to talk about what the topic is, which is the new copyright economy. Okay, so I want to talk about copyright and economy. In order for copyright to work, you have to have effective protection of copyright owners and effective enforcement. And I'm really glad Chris is here because he talked about a lot of things that I'm really interested in, such as the Copyright Small Claims Court and trying to help improve registration. But you also have to talk about the economy that works both for the creators and for the delivery system. It seems that right now everyone is putting all the value in the tube. Who is delivering you the content? It's the Google and YouTubes. But they make all their money because people want to go to them because there's content on them. And we have to start thinking about how the new economy is going to work for everybody. I'll just hit everybody. Whoa. All right. So the question is, in this new copyright economy, is it really working for the content owners? And what you see, and now I'm going to sort of go away from the relationships that Sean's talking about, which involve contracts, where you have a real exchange between a publisher who wants to either sign or license a photograph, to the way images are used almost in a more public sense. It says there is so much unauthorized use online and the internet, and you saw from Roy's first slide, is that the percentage of people who either think copyright's in the way or they think everything online is free, is that there's a real disconnect now between copyright users, because they're the public instead of the professional publishers and film producers, etc. And then the other issue is you really have no recourse against a lot of these users infringers, because the last thing you want to do is go after every kid in the living room. The RA had a disaster, suing every college kid that's downloading music. It makes everyone think that copyright is bad, and you get the reputation of being a copyright troll. And that doesn't really seem the way to solve the problem either. So the original bargain is what we got essentially from Congress. You got a monopoly, as I said. So a creator has the right to own exclusive rights, which is essentially giving them the economic value of their work for a period of time. And everyone can talk about, is it too long? Have they gone too far? But the idea is that creativity comes from the creator and not from the users who exploit it. And this is just the review of what all these nice bundle of rights were given under copyright. The reproduction right, the display right, the right to distribute and to make other works for it. And so, everyone knows that we have a new cultural issue. We don't have to talk about how much sharing is going on, how much right-clicking is going on. And because our copyright laws give these bundle of exclusive rights, the sites try to immunize themselves in many different ways, so they're not responsible for what the users upload. They have broad terms and conditions, so if you pin something on Pinterest, you're claiming that you own it, so they can, say, well, everything up here is protected. And there are just limited ways in which you can handle these things. The DMCA gives you the right to write a takedown letter to these sites if they see your work, but can you imagine scanning the internet constantly and trying to find each use every time your photographs use Sean and then trying to write a letter? I mean, you would never have time to take a photograph. There's some great services like PicScout and others that can match your photographs to web uses, but then you have to figure out if someone licensed it. So there's no easy answers right now. Some of the sites think it's great. Pinterest has an attribution policy, but attribution, again, doesn't give you any kind of money. It doesn't. And it only works if the image that was pinned really came from your site. So if you had licensed an image to a magazine and it gets pinned from the magazine, it's not going to go back to your site. then I know we're getting some legal water here, but ISPs like this umbrella of this safe harbor, which protects them from any lawsuits for money damages. And the bargain in that situation is that they have to agree that they'll take it down if you ask them the right way. So you have to ask nicely, you have to do it the right way, and they can take it down expeditiously. No one knows how long it is. So if all the value is because you had an exclusive picture up for the first day, and it kind of takes them 2 or 3 days to take it down, then that's really what happens. So you can't go after the ISP for monetary damages. You could go after the website, but they may not be in the U.S. And again, as Chris said, cost about $300 just for an index number in federal court. You have to have the work registered. It's just not effective to try to enforce rights that are used in these kind of social sites through the federal court system. So these are what you need to have a proper notice and takedown letter. And if you do any one of these things wrong, they can ignore you. And here, this is what a website needs to do in order to be protected under the safe harbor. So it isn't automatically if you're a website, you get the protection. You do have to remove content, but there's all these legal issues going on with Google and YouTube. Is how much do you need to know, and how much responsibility ISPs have in policing. So far, the courts have not really required the ISPs to do much policing, and they really left the whole burden of trying to protect your work up to the individual creator to provide notice to an ISP. And in order to be protected, the ISPs also need a repeat infringer policy, and what that really means. So if the same images get uploaded by 10 different users, and you get a notice to take down from one, does that mean the ISP will go and search and take down the other 9? No, they need to get 10 notices. So then the other way that a lot of websites are, using work without authorization is the big umbrella of fair use, which, as Chris so aptly explained, is really a set of guidelines and not a lot of rules. But the courts have been, recently there's been some very expansive rulings on fair use. And in fact, there was a case that came out a couple weeks ago, the Authors Guild versus Hathaway Trust. Those are all the libraries that got all the 20 million books from Google. And these are the libraries that are allowing anyone to come into their library and use them. The Authors Guild brought a case against this aggregator of all the books, and Judge Baer just said that this is fair use because the idea is so transformative that you can now search books by words and find things, and also that the books can be read aloud to blind students. So the fact, which is great, that blind students can have the same reference material as seeing students, but in a way, just like to make an exception that helps blind students is just like blowing a hole through copyright, bigger than the side of this building, in my opinion. I don't know what Chris thinks.
Part of the end about authorized entities we were referring to was surprising. Very, very broad.
Yeah, it was very, very broad.
Yeah.
And so the future is a little, without having these types of narrow restrictions in our Copyright Act, and the reason we have it so flexible has made the rights of creators very unsure. You don't know what the large ISPs can do. And of course, when you're an internet company, all you want to know is on and off switches. Everything is zeros and ones, and copyright is a big off switch. So the most you can avoid being restricted by copyright, the better you are. So there's many, licensing models. I know it's very confusing often for those that are licensing content. We have the RF, and we have RM, we have broad rights. But there's nothing that's really effective in the US for uses that are done by users which aren't authorized and sort of like after the fact. So in I don't know if anyone here was at this conference I was at last weekend, but we talked about a endeavor that the ASNP and PACA is looking into with the Copyright Clearance Center to try to figure out if the time is right now for some voluntary collective licensing agreement that would handle these social sharing sites. It would not deal with the transactions that go on between a photographer, a photo library, and a magazine or a publisher, but for all those user transactions that are so far, you can't collect any money for them, and you can't afford to go to court to prevent them, and you can't even afford the time to send takedown notices. So what we're talking about is investigating a license that really would try to aggregate the professional content that's being shared on the Pinterest, on these social sharing sites, and try to figure out if there's a way to come to them with a large enough bundle of images that you can offer a license that would prevent them from having to worry about if they had done all the right things under the safe harbor of the DMCA, and would also prevent their users from being subject to litigation, and see if there is a way that we can put copyright and economy back together. So when it's clear, it's not a replacement for your professional license agreements, but really is to cover what is just completely falling out of the box right now. And we can talk a lot about it more later. I know we don't have a lot of time, but it really would be a grant of right to the domain. We would try to capitalize the technology that's available now, the image recognition technology, and try to figure out how we can gather this data and really, give back royalties that are based on usage. And I think we'll just leave this here, because I was going to talk about Copyright Small Claims Court and improving the registration system because of blogs and photos, but Chris did such a good job that we'll just hold for questions. And that case that Sean put up there, that was my case really throughout all my registrations.